Have you ever found yourself just, staring at a dense legal document or maybe any complex subject and just felt instantly overwhelmed,
Uh-huh.
wishing someone could just cut through all the jargon and tell you what really matters?
Definitely. That feeling is pretty common, I think.
Well, if that sounds familiar, you are absolutely in the right place because that's pretty much our mission today.
Indeed. We're about to dive deep into the, intricate but really foundational world of South African civil litigation.
Right.
And specifically, we're going to unpack the enduring wisdom of a book that's, it's practically legendary among legal pros here, Amler's Precedents of Pleading.
That's the one. Amlers. And it's so much more than just a book of legal templates, isn't it? It's like an indispensable guide.
Absolutely.
Our goal in this deep dive is really to be your guide to understanding Amlers, not just as, pre-written forms, but as this robust framework for intellectual rigor, for critical thinking in law.
Mm-hmm. We want to extract its core wisdom, sort of show you how legal experts actually build cases from the ground up.
And why this book is, more profound than it might first seem.
Exactly. So by the end of our chat, you should have a good grasp of the core philosophy behind effective legal drafting.
You'll understand those critical distinctions that define legal arguments.
And you'll see the whole journey of a lawsuit, from the first step right through to resolution.
All through the lens of one of South Africa's really key legal texts.
Precisely.
All right, let's get into it. We're starting right at the heart of Amlers. Its foundational principles, its unique philosophy.
Okay.
So first up, the role and purpose of Amlers. Why is it more than just templates? This guide has been shaping civil litigation here since, 1956?
That's right, since 56. And what's really defining about it is how it's seen as a work of first reference.
A work of first reference. What does that mean exactly?
It means it's not trying to be some huge legal encyclopedia covering everything under the sun. No. Instead, it's the essential starting point.
The first place you go?
Exactly. For any claim or any defense. It gives you that foundational structure, concise summaries of the actual law involved.
Okay.
And these crucial notes on the why, the rationale behind arguments, even touching on who has to prove what, the burden of proof.
So it's efficient for lawyers, but also helps learners understand the core.
Precisely. Busy practitioners get quick access, alphabetically arranged topics. Learners get the core structure. It's designed for that rapid, reliable reference.
So understanding Amlers means learning how to quickly find and use these core structures. It's about efficiency and understanding.
You got it. And that leads perfectly into its, brilliant pedagogical intent, its teaching mission.
Go.
Judge Louis Harms, the author, he famously says the precedents are illustrative only, flesh is lacking.
Flesh is lacking. That sounds deliberate, almost like a warning.
It is deliberate. It's not a flaw. It's the core design. It's meant to fight against what advocate Ismail Hussein SC warned about. When you use a precedent, you don't think.
So the bare-bones structure is intentional, to stop mindless copying.
Exactly that. It's a direct challenge to just unthinkingly relying on templates. If you just copy-paste, you risk pleadings that don't fit the actual facts of your case.
Which leads to problems down the line, delays, costs.
Right. Amlers forces you to put in the intellectual work. It demands that you apply your own analysis, your own thinking, tailor the legal principles to the specific situation.
So it's really about building professional competence, not just finding a form.
Precisely. It's like a training manual disguised as a reference book. It makes you engage your brain.
That's a really powerful way to think about it. Now, speaking of change, the legal world isn't static. How has Amlers kept up since 1956?
Oh, it's evolved continuously, mirroring South African law itself. Every new edition reflects big changes.
Like what kind of changes?
Well, new topics get added, things like admiralty claims, close corporations, stuff that wasn't as prominent before.
And old stuff gets removed.
Irrelevant sections get omitted, yeah. And the content's been rearranged over time to make it more user-friendly.
I heard there was a pretty big structural change recently, in the 9th edition.
That's right, 2018. The 9th edition split the book into two main parts. Part A, Principles of Pleadings, that gives you a practical, 11-page overview of the fundamentals. A bird's eye view.
Handy. And Part B?
And Part B, Notes and Precedents. That's the more traditional detailed section with the examples. And the latest one, the 10th edition from 2024.
Yeah.
It shows, and I'm quoting here, greater awareness of the Constitution and the jurisprudential work of the Constitutional Court and the Supreme Court of Appeal.
So it's constantly being updated to reflect the highest courts in the Constitution.
Absolutely. That continuous adaptation is key. It ensures Amlers stays relevant and aligned with modern practice and the supreme law. The takeaway for you is seeing how vital it is for guides like this to evolve.
A living document, just like the law.
Uh-huh.
Okay, let's shift gears. Part 2. The canons of pleading, the language of the courts. Sounds like we're getting to the real grammar of legal arguments.
We are. This is about the rules of engagement, you could say.
So what's the main job of pleadings? Why do we even have them?
Their core purpose, really, is to define precisely what's in dispute. For the parties involved, it's about procedural fairness. It stops what we call trial by ambush.
No surprises in court.
Exactly. And that's rooted right in the Constitution's Section 34, the right to a fair hearing. Parties are strictly held to what they've actually pleaded.
So it keeps everyone focused on the agreed-upon issues. What about for the court?
For the court, the pleadings basically set the boundaries of the case. They tell the judge, this is what you need to decide. While courts always aim for justice, they're fundamentally limited to adjudicating the disputes the parties have actually raised in those documents.
So a good pleading isn't just nice to have, it's foundational.
It is the foundation. A weak pleading means a weak case. Simple as that. Understanding this helps you see that pleadings aren't just paperwork, they're crucial for fairness and efficiency. They define the whole fight.
Okay, now for what you call the golden rule. Facta probanda versus facta probantia. This sounds absolutely critical. Break it down for us.
Right. This is probably the most critical principle and honestly where a lot of confusion can happen.
Okay.
Facta probanda, those are the material facts, the essential things you rely on for your claim or your defense, the core allegations you must prove to win. Think of it as the what of your case.
The what? Got it. And facta probantia.
That's the evidence you'll use to prove those material facts. The testimony, the documents, the expert reports, that's the how.
The how. Okay, what versus how?
And here's the absolute key. Facta probantia, the evidence, the how, has no place in the formal pleading document itself.
Wait, really? You don't put your evidence in the pleading. That feels odd to a non-lawyer. Can you give an example?
Sure. Let's take a breach of contract case. Your facta probanda, the what you plead, would be things like 1, the contract exists. 2, these were its key terms. 3, the other side breached those terms. 4, you suffered damages because of it.
Okay, just the core facts.
Right. Now, the facta probantia, the how you'll prove it, that's maybe the witness who saw the contract sign, or an email where the other party admits they were late, or a quote showing the cost to fix the breach. That evidence comes out later, during discovery or at the trial, not in the initial pleading.
Okay, that makes more sense. Another example, maybe defamation.
Good one. For defamation, the facta probanda are 1, someone published a statement. 2, that statement was defamatory, meaning it hurt your reputation either obviously per se or because of specific circumstances, innuendo. 3, the statement was about you.
The what again?
Exactly, the facta probantia. That could be a screenshot of the nasty tweet or testimony from people who saw it and thought less of you. Evidence for trial.
So understanding this difference explains why Amler's precedents look the way they do.
Absolutely. Amlers is essentially giving you curated lists of the necessary facta probanda for different types of cases. And here's another important point. Even if you label your case slightly wrong legally, if you've pleaded all the necessary facts, the facta probanda your claim can still stand. The court looks at the substance, the facts pleaded.
That's crucial. Focus on the material facts. So mastering the what versus the how is paramount.
It dictates everything about how you draft.
And to make sure everyone follows these principles, we have the uniform rules of court, kind of like the official grammar rules.
You could say that. And the absolute cornerstone is Rule 18.4.
What does that say?
It says, every pleading shall contain a clear and concise statement of the material facts, with sufficient particularity to enable the opposite party to reply thereto.
Clear, concise material facts, enough detail to reply. Seems logical.
It encapsulates the core principles perfectly. Then you have other specific rules, like Rule 18.6 for contracts.
What does that add?
It demands clarity. Was the contract oral or written? When? Where? Who made it? And crucially, if it's written, you must attach a copy to your pleading.
Leaves no room for doubt.
And then there's Rule 18.10, which is vital for personal injury claims.
Damages claims. What does that require?
It demands incredible detail. You can't just say, I was injured and want money. No. You have to state your date of birth, the precise nature and extent of your injuries, any resulting disability.
Okay.
And this is key. You have to separately list and calculate the amounts claimed for different types of damages: medical costs, past and future, pain and suffering, lost income, and how you calculated it. It's very specific.
Now, that level of detail seems essential for the other side and the court to actually understand the claim.
It is. Compliance ensures clarity, informs the other side fully, and actually helps facilitate fair proceedings and even settlements. If you don't comply, your pleading can be deemed defective, causing delays. So the rules really enforce the principles in practice.
Got it. The rules ensure clarity, conciseness, fairness. Fantastic. Okay, we've got the philosophy and the rules. Let's move to part 3. The anatomy of a lawsuit, the sequence of pleadings. This is where we see it all happen in order.
Right, the actual back and forth of the documents.
So what kicks things off? The very first step.
It starts with the plaintiff issuing a summons. This is the document that formally notifies the defendant about the claim and calls on them to defend it if they disagree.
Okay, a summons. Are there different kinds?
Yes, two main types. First is the simple summons. You use this for what's called a debt or liquidated demand,
Meaning?
a fixed amount of money or an amount that's really easy to calculate precisely, like an unpaid invoice for our $10,000. The simple summons just gives a very brief outline of the claim.
And if the claim isn't for a fixed amount, like damages for an injury?
Then you use a combined summons. This is for unliquidated claims where the amount isn't fixed, like damages or in divorce cases. The combined summons actually bundles the summons itself with the full particulars of claim.
Which is?
That's the detailed pleading, setting out all the material facts, complying fully with Rule 18 that we just discussed.
Okay, and what's a declaration?
Right. If the plaintiff started with a simple summons, and the defendant decides to defend the case, the plaintiff then has to file a separate detailed pleading called a declaration. It serves the same purpose as the particulars of claim in a combined summons. So you differentiate based on whether the claim is for a fixed amount or not.
Right, so the summons goes out, the defendant receives it. What's their formal response called?
That's the plea. This is the defendant's formal answer to the plaintiff's allegations laid out in the particulars of claim or declaration.
And what does the plea have to do?
Rule 22.2 is the key here. It says the defendant must deal with each material fact alleged by the plaintiff. They have to either admit or deny or confess and avoid each one.
Admit, deny, or confess and avoid. Let's unpack those. Admitting is straightforward.
Yes. If you admit a fact, it's taken as proven. No need for the plaintiff to lead evidence on it at trial. So admissions have big consequences.
Okay. And denying.
Denying means you dispute the fact. You're putting the plaintiff to the proof, basically saying, you alleged it, now you have to prove it. This signals an active contest on that specific point.
Makes sense. What about confess and avoid?
That's where you admit the plaintiff's factual allegation is true, the confession, but then you raise some new factual matter that justifies or excuses your position, the avoidance. Like, yes, I signed the contract, but I was coerced.
Ah, okay. And what about just not admitting something? Is that different from denying?
Yes, it is, and it's a really important tactical distinction. A non-admission is typically used when the defendant genuinely has no knowledge of a particular fact alleged by the plaintiff, like maybe the plaintiff alleges something that happened between them and a third party.
So you can't really deny it if you don't know.
Exactly. Pleading a non-admission still puts the plaintiff to proof on that point, but crucially, if you plead a non-admission, you generally cannot lead contradictory evidence of your own at trial regarding that fact. Because leading evidence would imply you did have knowledge, making the non-admission improper and potentially prejudicing the plaintiff. Your ability is usually limited to cross-examining the plaintiff's witnesses on that point.
Wow, so the choice between denying and not admitting is a big strategic call.
Huge. It shapes the issues for trial and what evidence each side can present. Understanding these responses is key.
Definitely. So after the plea, is that it? Or can more documents be exchanged?
Oh, there can be more. For example, the defendant might have their own claim against the plaintiff arising from the same situation.
Like a counterclaim?
Precisely. That's filed as a claim in reconvention along with the plea.
Okay. And can the plaintiff respond to the plea?
Yes. If the defendant's plea raises new factual allegations, like in a confess and avoid defense, the plaintiff can file a replication to specifically address those new facts.
So it's a potential chain. Summons particulars, plea, plus initial counterclaim, maybe a replication.
Exactly. This whole exchange of documents continues until the issues are fully defined. And that leads to a crucial stage called latus contestatio.
Latin. What does that mean?
It literally means the joining of issue. It's the point where the pleadings are officially considered closed, the battle lines are drawn.
And why is that moment so significant?
Rule 29 sets out when pleadings close, basically, when all the necessary responses have been filed or the time limits have passed. Litis contestatio is important because it formally crystallizes the dispute. It has various legal consequences, like in common law, it historically affected whether certain personal claims could pass to a deceased person's estate.
So it marks the end of the defining stage and the start of preparing for trial.
That's a good way to put it. The sequence progressively narrows things down until the dispute is ready for the court to adjudicate. You need to be able to trace this whole sequence.
Fantastic overview of the process. Now let's apply all this. Part 4. A compendium of causes of action and defenses. Let's see how these principles work in specific types of cases, starting with delict civil wrongs. How about defamation?
Okay, defamation. Protecting reputation. To get a case off the ground, the plaintiff needs to plead and prove 3 core facta probanda. 1, publication the statement reached at least one other person.
Okay.
2, the statement was defamatory. It would tend to lower the plaintiff's reputation in the eyes of reasonable people. This can be obvious on its face per se, or depend on context, innuendo, which needs specific circumstances pleaded.
Right.
And 3, the statement referred to the plaintiff.
Got it. Publication, defamatory meaning, reference to plaintiff. Now, I heard there's something surprising about what happens next. A shift.
Yes, this is where it gets tactically interesting in defamation law. Once the plaintiff proves those 3 things, the law presumes 2 more elements are present. Wrongfulness, that the publication was unlawful, and intent, the animus injuriandi, or intention to injure.
Whoa, they're just presumed. The plaintiff doesn't have to prove them initially.
Correct. The burden of proof actually shifts entirely to the defendant at this point. It's up to the defendant to plead and prove a valid defense that justifies the publication.
Like what kind of defenses?
Common ones are truth and public interest. The statement was true and it was beneficial for the public to know. Fair comment. It was an honest opinion on a matter of public interest based on true facts. Or privilege, like statements made in parliament or court.
That's a massive advantage for the plaintiff, having wrongfulness and intent presumed.
It is. It makes establishing a prima facie defamation case somewhat easier than many other delicts. Cases often turn on the defendant's ability to prove their defense.
Okay, let's switch to another common delict, personal injury claims. These often involve significant damages.
Yes, and because of that, the pleading requirements are particularly strict, especially regarding the damages claimed.
So what are the facta probanda here?
You still need the basic elements of delict. A wrongful act by the defendant, fault, usually negligence, causation, the act caused the harm itself, the injuries, and the resulting damages, losses.
Well, you mentioned Rule 1810 was key here.
Absolutely crucial. Rule 1810 demands extreme particularity for the damages part. You must plead the plaintiff's date of birth, the exact nature and extent of the injuries, any permanent or temporary disability.
Okay, very specific on the injuries.
And critically, you have to separately quantify the different heads of damages. You need specific amounts with calculations shown for things like past medical expenses, future medical expenses, past loss of earnings, future loss of earnings or earning capacity, and general damages for pain and suffering, loss of amenities, etc.
So a detailed breakdown and justification for every rand claimed.
Precisely. It's designed for transparency to allow the defendant and the court and insurers to properly assess the claim, which hopefully facilitates quicker settlements.
Makes sense. What if the injured person was partly at fault themselves, like not wearing a seatbelt in a car accident?
That brings in the defense of contributory negligence. This is based on the Apportionment of Damages Act from 1956. Before this act, South Africa had an all-or-nothing rule. If you were even slightly negligent yourself, you got nothing.
Harsh.
Very. The act changed that. Now, if the defendant pleads and proves that the plaintiff's own negligence contributed to their damages, the court will apportion the fault. Meaning the plaintiff's damages award gets reduced proportionally to their degree of fault. So if the plaintiff is found 20% responsible, their damages are reduced by 20%. It's about fairness. So for delict, you need to grasp the specific facts needed, any legal presumptions like in defamation, and the high detail required for damages.
That apportionment seems much fairer. Okay, let's move to contract law. Breach of contract must be one of the most common claims. How do you plead that?
For a standard breach of contract claim, the plaintiff needs to cover several key facta probanda. First, plead the existence of a valid contract. Rule 8(6) applies here. State if it was oral or written, when, where, by whom it was made, and attach a copy if it's written.
Okay, prove the contract.
Second, set out the material terms of the contract that are relevant to the breach. Third, allege that the plaintiff fulfilled their own obligations under the contract or explain why they didn't need to.
Right, you did your part.
Fourth, and this is central, plead the specific breach by the defendant. What exactly did they do wrong? Was it late delivery, more debitoris, defective performance, positive malperformance? Did they signal they wouldn't perform at all, repudiation, or did they make it impossible for you to perform, prevention of performance? You need to specify the type of breach.
Be precise about how they failed.
Yes. And fifth, plead the damages you suffered as a direct consequence of that breach and how they are calculated. Finally, you state your remedy usually. You elect to either claim specific performance, force them to do what they promised, or cancel the contract and claim damages.
Clear steps. What about a claim on a suretyship, where someone guarantees another person's debt?
Suretyship claims are also common. The core facta probanda there are: 1. The existence and amount of the principal debt, the debt being guaranteed. 2. That the defendant sign a valid suretyship agreement covering that debt. Attach a copy. 3. The material terms of the suretyship. 4. That the principal debtor defaulted on their debt. 5. That demand was made on the surety, the defendant, for payment if the agreement required it.
Seems straightforward enough if you have the documents. What are common defenses in contract cases?
Oh, lots. Defendants might simply deny the contract existed, or deny specific terms, or deny the breach happened. They might rely on non-variation clauses, the contract can only be changed in writing, or plead that performance became impossible due to unforeseen events, or argue the contract was illegal. Understanding these basic contract elements and defenses is key.
Definitely. Okay, shifting to property law. The term re vindicatio sounds imposing. What is it?
It is imposing, in a legal sense. It's the primary action an owner uses to recover their property from anyone who possesses it unlawfully. It's incredibly powerful.
Why powerful? What do you need to plead?
Because the facta probanda are remarkably simple for the plaintiff, you only need to allege and prove two things. 1, that you are the owner of the thing. 2, that the defendant is in possession of it when the action starts.
That's it. Ownership and possession. That seems too easy compared to other claims. What's the catch?
Here's the aha moment. Once the owner proves ownership in the defendant's possession, the law presumes the possession is unlawful. The legal burden then shifts entirely to the defendant.
So the defendant has to prove they have a right to possess it.
Exactly. The defendant must plead and prove a valid legal right to possess the property, like a lease agreement or a lien. If they can't, the owner gets the property back. That shift in onus makes it a very strong remedy for owners.
That is powerful. What if the property can't be returned? Maybe it was destroyed.
Then the owner might use a different action, the actio ad exhibendum. This is a claim for damages against someone who wrongfully disposed of or destroyed the property knowing the owner's rights. But here, the onus is heavier on the plaintiff. They have to prove the wrongful disposal and the defendant's knowledge.
Interesting distinction. What about eviction cases, especially with the PIE Act involved? Prevention of illegal eviction.
Yes. PIE applies to evicting unlawful occupiers from residential land. It adds significant layers due to constitutional protections around housing.
So what must the applicant, usually the owner, prove?
They still need to prove the basics: their ownership or lawful control of the property, and that the respondents are in unlawful occupation, e.g. their lease expired or they never had permission.
But there's more to it.
Yes. The key detail under PIE is that the applicant must also plead facts that will persuade the court that granting an eviction order is just and equitable in all the circumstances.
Just and equitable. What does that involve pleading?
It means the applicant should provide information about the occupier's personal circumstances as far as known. Are there elderly people, children, disabled individuals, female-headed households involved? How long have they lived there? The court must consider these factors, along with the owner's rights, before ordering an eviction.
So it balances the owner's rights with the occupier's situations.
Precisely. It makes eviction proceedings more complex than a simple re vindicatio. You need to appreciate the power of onus shifts in property claims and the special social justice considerations in PIE evictions.
Very important societal context there. Let's touch on matrimonial causes. Divorce. South Africa uses a no-fault system now, correct?
That's right. The primary ground for divorce is the irretrievable breakdown of the marriage relationship. You don't need to prove adultery or cruelty like in the old days.
So what are the essential things to allege in a divorce summons?
You need to establish jurisdiction, that the court has power to hear the case. Provide full particulars of the parties and the marriage itself, date, place, and crucially, the property regime, in or out of community of property accrual. You then need to state the factual reasons why the marriage has broken down irretrievably. And, very importantly, full details about any minor children born of the marriage.
And what does the plaintiff actually ask the court for? The prayers.
The prayers need to cover everything needed to dissolve the marriage and sort out the consequences, typically. 1, a decree of divorce. 2, orders dealing with patrimonial consequences, division of the joint estate, enforcement of an antenuptial contract, ANC, perhaps forfeiture of benefits or redistribution of assets in certain cases.
Okay.
3, orders regarding parental rights and responsibilities for the minor children, care, contact, guardianship, often incorporating a formal parenting plan. 4, orders for maintenance, if applicable, for a spouse or the children.
What about uncontested divorces where parties agree?
In those cases, they'll draft a settlement agreement covering all these issues. That agreement is then attached to the summons, and the prayers ask for it to be made in order of court.
Got it. And quickly, you mentioned testamentary drafting writing wills. How do the principles we've discussed apply?
While writing a will isn't pleading, the underlying principle is identical. Clarity and precision are paramount. Ambiguity in a will leads to disputes and costly litigation after someone dies, just like a vague pleading causes problems in court.
So, same need for careful drafting.
Exactly. And wills have strict legal formalities under the Wills Act that must be followed precisely. It must be in writing, signed at the end by the testator, on every page ideally, and signed by 2 or more competent witnesses who are present at the same time, all signing in each other's presence. Lack of precision or failure to follow formalities can invalidate the whole will. Understanding divorce requirements and the parallel need for precision in wills is key.
An absolutely vital point. Okay, this has been incredibly insightful. Let's bring it all together in our final section. From precedent to practice. Modern legal drafting. How do you actually take Amler's bare bones and turn them into a proper pleading?
Right. This is the art of drafting. It's definitely a skill, not just admin work. You can think of it as a systematic, maybe 5-step process.
Okay, lay it out for us. Step 1.
Get the facts. This is crucial. Interview your client thoroughly. Dig through all the documents. Identify the evidence you have to support the claim. You need the full picture first.
Makes sense. Step 2.
Identify issues and cause of action. Now you apply your legal knowledge. Analyze the facts. What's the correct legal basis for the claim or defense? Pinpoint the specific facta probanda you need to plead for that cause of action.
So legal analysis meets facts. Step 3.
Find the law and precedent. Now you turn to your resources. Amlers is the work of first reference. Study the notes for your cause of action. Find the relevant bare bones precedent.
Use Amlers as the starting skeleton. Step 4.
Apply law to facts the drafting. This is the fleshing out we talked about. You take the Amler skeleton and you populate it with the specific material facts from your client's unique situation. This is the intellectual input Amlers compels. And you make sure you follow the uniform rules, clarity, conciseness, Rule 18 requirements.
This is where the real skill comes in. And step 5.
Conclusion and formulate the prayer. Your pleading needs a clear ending. A logical, legally sound prayer for the specific relief you want the court to grant. This prayer must flow directly and logically from the facts and legal arguments you've set out.
Get facts, identify issues, find precedent, flesh it out with facts, state the relief. That's a solid process.
Following that ensures your pleading is bespoke, logical, legally sufficient, and factually accurate. It teaches that systematic transformation from narrative to formal document.
Excellent roadmap. Now, in today's world, lawyers aren't just using books. What's in the modern litigator's digital toolkit? Where do they find precedents and case law online?
Right. Modern practice definitely blends traditional skills with technology. For finding case law judgments, the Southern African Legal Information Institute, or SFLII, is absolutely indispensable.
SFLII, I've heard of that.
It's a fantastic free online resource. Thousands of South African court judgments. You use it constantly to find recent decisions. See how courts are interpreting pleading rules now. Find real-world examples of how issues are framed.
Essential research tool.
Yeah.
What else?
Then there's Court Online, often referred to as case lines. This is the electronic filing and case management system being rolled out in the high courts. It's becoming essential for practice moving towards paperless litigation. You file and manage your case documents digitally through it.
So digital proficiency is non-negotiable now. Are there places to find, like, other templates or forms online?
Yes, you do find supplementary forms or basic templates on sites like LegalWise, iLawyer, or even the Law Society's resources sometimes.
But I sense a but coming.
A very big but. Here's the crucial cautionary note. You have to use these online templates with extreme caution. They are absolutely not a substitute for Amler's detailed notes and structured precedents, nor are they a substitute for your own critical thinking and intellectual input.
So don't just download and file.
Please don't. The risk of using a generic template that doesn't fit your specific facts is huge. It goes against the very philosophy Amlers teaches. The modern lawyer needs that hybrid skill set, deeply grounded in the foundational principles and proficient with digital tools, but using tech to enhance the legal thinking, not replace it. Knowing the tools is important, but knowing how and when to use them critically is paramount.
That's a critical warning.
Yeah.
Technology as a tool, not a crutch. So wrapping this all up, what are the core things you hope our listeners take away from this deep dive into Amlers and pleading?
Well, first, I hope you see Amlers not just as a book, but as a kind of philosophical guide. It teaches you how to think about structuring a legal case, pushing for that intellectual engagement over just copying.
Right. Think, don't just type.
Second, that distinction between facta probanda, the material facts, and facta probantia, the evidence, is genuinely the single most important concept. It dictates the language courts understand.
Master the what versus how.
Third, that pleading is inherently strategic. Every choice you make, what to admit, deny, not admit, how you frame the facts, has downstream consequences for the whole case.
It's a tactical exercise from day one.
And finally, that modern legal practice demands both timeless intellectual rigor, the kind Amlers fosters, and digital literacy. You need both to be effective today.
A blend of old school thinking and new school tools. That's a great summary. It really has been insightful. The law, as you said, is always evolving. And for anyone learning about it, the journey isn't just memorizing rules. It's about cultivating that critical thinking, that adaptability.
Exactly.
So maybe a final thought for you, our listener. Having explored all this, what specific legal challenge or document are you now perhaps looking at differently, armed with the power of focusing on the facta probanda and adopting the strategic mindset of a seasoned pleader? Something to mull over.